Hello everyone and welcome to today's Mondac webinar in association with Matheson LLP. Thank you for joining this deep dive into the Irish landscape for blockchain and digital assets. My name is Dan Sampaio and I'm very pleased to be joined by a wonderful panel to take us through this discussion. But before I hand over, a housekeeping item. You're able to submit questions by typing them into the toolbar on the right-hand side of your page, and we will endeavour to answer as many questions as possible. It's now my pleasure to hand you over to our panel, and first a message from Matheson.
Hello everyone, it gives me great pleasure to welcome you all to this webinar on Digital Asset Revolution, a Roadmap for Success. Today, we will explore the opportunities and challenges brought by the ever-accelerating growth of blockchain, cryptocurrency, and virtual assets. We will be delving into the potential here and posing possible solutions to help bridge the gap between the traditional financial world and the virtual world, which includes the new world of Web3. This is an increasing and ever-increasing focus for Matheson, and we're working alongside our clients to navigate the complexities and the ever-changing developments born by people with great creativity, and many, I'm delighted to say, have joined us online. The opportunity for business in and Ireland at a local, national, and global scale cannot be overstated. Companies big and small, and with an international focus, seeking to do business in or from Ireland, are looking at Ireland as it embarks on its partnerships in this new era. I find it helps to take a brief moment to explain a bit of the jargon. So imagine this: blockchain is the train tracks, cryptocurrency is a type of train engine, The NFTs or digital assets are the train carriages, and perhaps even our financial regulators could perhaps be called or qualify as the train conductors, or maybe the train inspectors. With all trains, there is a driver, there's a leader, and at Matheson, we're seeing the drivers locating in Ireland. The train tracks, engine and carriages are each being built and maintained in Ireland in partnership with our global friends. So please keep this in mind. As I now want to introduce my colleagues and friends, so we have Karen Reynolds, a partner in our investigations team, and Ian O'Mara, a partner in our financial services regulatory practice, with a focus on payment, fintech, and crypto firms. And for myself, I'm Rory O'Keefe. I'm a partner in our technology and innovation team, having worked 10 years previously as an in-house lawyer for a Fortune Global 500 company in the tech space. So we each form part of Matheson's wider digital economy group, which is a multidisciplinary legal team set up in anticipation of the ever-growing global complexity in this digital space. So as you may have recalled, if you have any questions at all, please do put in the box in the tool provided. And with a bit of luck and a bit of time on our side, we'll be happy to answer those ourselves. So let's start into the first obvious question that has been coming through to us regularly by our clients across each of our desks. What are the key legal emerging trends in this space, in the digital assets markets? So if I could turn to you, Ian, what are your thoughts on trends here?
Hi, Rory. Thanks for having me on the panel today, and great question to start off the session. So I suppose there's two key trends that we're seeing globally in this whole area at the moment. One is an area of, I suppose, enforcement action, largely being taken by the US authorities against crypto firms based in that jurisdiction. And I think oftentimes that approach has been informed by the lack of a clear regulatory framework for this sector, which is a common problem around the world. And while the US has been taking that approach in recent times, particularly since some high-profile events that took place in the market last year, there's also another track, which is countries and regions starting to pass legislation that, for the first time ever, carefully considers the needs of this sector. And that's what we're seeing largely in the European Union at the moment, in which Ireland is a member. And in the last few weeks alone, we've seen some groundbreaking legislation, such as the markets in crypto assets regulation and some other laws being passed at EU level. So they're really the two trends I think we're seeing in the market at the moment. And I think as we go through the questions during this webinar, we'll touch on these points a little bit more.
Thank you. Karen, from your desk, what are you seeing?
Well, my desk tends to be focused on the things that go wrong, or if you get to me early enough, I to stop the things going very wrong. And I'd absolutely echo what Ian has just said in terms of litigation and enforcement. US certainly taking the lead and seeing a little bit of regulatory dissonance, a bit of push-pull over there as well. We don't have the same problem because we just have, I suppose, one financial services regulator here, but we're at a very nascent stage in terms of our regulatory environment. But what I would say in relation to the litigation side of things, as has been happening in the US and other jurisdictions, the Irish courts are using established and existing procedures, rules, first principles to tackle and create relief and remedies for these new emerging technologies and the types of challenges that they throw up. And that's something that, from my vantage point, I find very exciting and certainly challenging in a interesting way, so to see the new ways that we can help clients navigate through those issues. I think also from the enforcement perspective as well, we're all waiting a little with bated breath to see what the final text of the new MiCA regulation looks like, because really the enforcement regime will be in the detail of that, which we have yet to see. And for those of you who are following the Central Bank of Ireland trends, you may have seen a recent blog post from our governor, who is certainly not quiet when it comes to digital assets and cryptocurrencies. Certainly has his microscope out and placing a lot of scrutiny on the types of assets and the types of pitfalls that end users and consumers can experience when investing in those crypto digital asset type investments. So certainly not adverse to them, but watching it very closely to ensure that regulation keeps apace with the technological advances, to ensure that consumers are protected and that there's an appropriate and robust framework in place. Enforcement is part of that, acts as a credible deterrent, and we've certainly seen that in each of the other financial services areas that we're experienced in advising, and I think crypto and digital is no different.
So just adding on to the regulatory oversight that we're seeing is, so what we're seeing, at least my desk in the tech space, is that we're encouraged by the fact that regulators, not just in Ireland but abroad, are embracing the reality of these digital assets and the requirement for regulation in some degree, I argue, and I hesitate to say that because of the original basis of the creation of this for cryptocurrencies and digital assets especially. Rather, blockchain's been around a lot longer in my head, but nevertheless it is interesting to see. But to add to that complexity, it's not just MICA that we're talking about from my perspective. We're seeing clients who are now live to the Digital Operation Resilience Act, DORA, and also NIS2, which is the Network Security Infrastructure piece as well, from the cybersecurity perspective. And it's not surprising. It is not surprising. We've been talking for years about trust in tech and the need for trust, need for, in the GDPR context, we talk about design being embedded into the actual whole process. So, and when we look at the cybersecurity implementation of that, plus DORA, NIS2, ISO, the IEEE context of different standardizations that we're encouraged to embrace and embed in order to ensure robustness and of rooting out vulnerabilities within the systems, it's no wonder that that has taken a greater focus for many of our clients today. And I point out to a lot of people who are privy to these types of regulations, they're not coming in force this year, DORA and NIS2 particularly. One will come in next year and the other will come in January 2025. But that doesn't mean that we're not looking at them now, because our clients are taking a proactive rather than reactive approach to regulation and encouraging a conversation with the various parties that will ultimately be providing us the guidance on how to implement and ensure this technology itself can be treated as trustworthy for consumers. But then, leaving aside regulatory, I think on my desk we're also seeing a concept called blockchain as a service. And to those of you in this will know software as a service, automation as a service, robotics as a service. Well, now it's blockchain as a service. And this is like third-party services being provided to allow companies to access the blockchain technology without having to build and maintain their own systems from scratch. So it's similar to the SaaS model, the idea being that it's more cost-effective, or attempting to be more cost-effective and to help streamline operations, which will be good news to many people who are dabbling or starting in this space, of course. And the third trend that we have seen, which is no surprise to a lot of people, is in the context of blockchain with artificial intelligence. So maybe 2 years ago, we were all talking about metaverse. The year after, we're talking about crypto and NFTs. And this year, the focus point seems to be around generative AI, the tools similar to ChatGPT, and how intellectual property is going to be protected. But with blockchain, we still won't be ignoring the GDPR issues, how they're going to be focused. And the use cases seem to be teetering on different areas, and some gaining more attraction. And one particularly will be in the digital identity management piece, which is similar to the anti-money laundering points that Ian was referring to earlier. So that's from my space. But going into the next common question that we're seeing, Ian, if I could turn to you.
Yeah.
What do you think this all means for Ireland?
Yeah, well, I think Ireland is very interestingly positioned when it comes to being a major player in the sector. So as a small open economy, Ireland has developed a financial services industry and a tech industry which is focused on providing financial services and other services into Europe and also internationally as well. And actually that's a real focus that our firm Matson has, on helping firms, doing business in and from Ireland. And what we've seen over the last number of years, certainly in the area I'm advising on, is that quite a number of the large crypto exchanges and platforms have set up in Ireland to do traditional financial services, which are very relevant to their virtual asset and crypto asset service offerings. So, for example, we've seen a number of the major platforms get licensed as electronic money institutions or payment institutions, so that they can handle the fiat transactions that go when customers are looking to lodge fiat currency into their virtual asset platforms with a view to buying digital assets and so on. We've seen a lot of work in that space, and those firms, although headquartered or set up in Ireland, benefit from licensing provisions, which means that they can carry on business across the whole of the European Union without necessarily having to get authorizations in other countries. We call that a passport in financial services law in Europe. We've also had an interesting AML regime, which has required companies that are doing just a virtual asset service piece to get registered with the Central Bank of Ireland. And I think firms who have gone through those licensing processes now are very well positioned to capitalize on this new legal framework called MiCA, which we've discussed a little bit already on the call, which will allow firms to provide crypto services again across the whole of the European Union on a passporting basis once they've got their license to do that. So Ireland is in a very good position, and I think as well you'll find as a country we have a lot of the ecosystem. You know, we've very experienced professionals, we've a great educated workforce, we've an attractive corporate tax regime, and a very well regarded regulator as well. So all of these factors put Ireland in a great position, I think, to exploit the opportunities that are coming down in the years ahead.
I have to agree with that. I think it's an interesting position, because Ireland now is the only leading English speaking as a first language. I wouldn't say the best English speaking, because our friends across the continent are brilliant at conversing in multiple languages to our shame. But what I have noticed is that it's the only common law jurisdiction now within the EU. It is positioned very neatly because the Irish government, for example, issued the National Digital Strategy last year, which is embracing the innovation and the emerging technology space, not just in blockchain technology itself, but the broader spectrum of technology that's out there, and implementing the EU's digital finance package as a result, and as would be expected. But the other part is that with the new list of EU laws coming through, Ireland will be implementing those EU standards for cybersecurity under the DORA NIS2. Could be AI standards that will be complementing for the Artificial Intelligence Act, and we know that the importance, as I keep saying, is having trust is key to any financial market. It's key under the outsourcing guidelines for any financial institution that gets caught by DORA NIS2 or the existing outsourcing guidelines themselves. They all know that having continuity of services, the importance of those critical and important functions is supported by having the necessary infrastructure, and I mean the tech infrastructure in place in order to deliver those services in a seamless fashion without the potential of a potential enforcement action or litigation or something in that regard. And we've mentioned the Central Bank of Ireland, but we also should recognise the Irish Data Protection Commission, who has been issuing some of the biggest fines that you have seen or heard about, at least over the last number of years, with the a number of investigations due to be announced later this year. So it's very much a key position for Ireland to showcase the fact that it is a very safe place in that regard to set up business in this light part of the European Union. But I do want to check.
Rory, I was going to say as well, like, I mean, if you're interested in building a business with global ambitions, you know, setting up in Ireland is a great idea, because, you know, the frameworks here are just effectively the global standards, you know, be it GDPR, be it cybersecurity, be it licensing for this particular sector. You know, if you can build your business to those standards, likelihood is that they're going to, you know, meet the standards anywhere else in the world as well. So, you know, it's a great, if international expansion is your ambition, I think it's a, you know, it's a really critical location to consider for setting up, you know.
I think we're somewhat biased, so We won't continue to talk too much about this for fear of losing our audience as well in the process. But so we're painting quite a happy picture of things in the field for Ireland, but that would mean we don't need you, Karen, at all, because everything's all great. There's no pitfalls that we should be aware of, no enforcement actions that we should be considering in that regard. But I doubt you would agree with that statement.
Well, I'm certainly very busy, so I suppose that tells its own story. But I think part of that as well is that what we offer, I think, is a sort of regime and environment where certainty is as good as it can be in any other jurisdiction, and I suppose ahead of some jurisdictions. And I think if you look at our track record in Ireland, we've had quite a number of firsts as well. We handled a lot of the Madoff litigation, the Bernie Madoff Ponzi scheme. Some of that litigation was brought in Ireland ahead of the US, which I think is a testament to our court system and the way in which the courts can deal with novel, complex litigation. And certainly being able to flex and respond to the types of challenges that arise in this arena is something that is extremely important to market players. And it's not just the consumer, but also those who are offering the services. It is a good calling card. It's a good characteristic of your business to be able to say we're located in Ireland and there is certainty there. Now, I shouldn't overstate the certainty, of course, because it is an emerging area. But in terms of some of the applications that we're seeing and that we've been involved in, there are certain challenges, of course, and one of those is particularly in relation to jurisdictional questions. So often if somebody approaches me and they say, my assets have been misappropriated, I don't know who's taken them, I've been hacked, I've received a ransom call, we're looking at, well, what types of applications can you take? How can the courts assist? And often what you're looking at is a crypto or cyber type injunction. And that's fine if you know where the person, the bad actor, is located. It's relatively easy to at least understand what you're looking for and against whom you're looking for, but very often you don't know. You've got persons unknown, and these types of applications are common to many, many jurisdictions. There is an established procedure in Ireland to bring those types of applications, but if you're looking at potential bad actors outside of the EU or Lugano states, it becomes a little bit more difficult because you have to fit within certain established gateways, certain procedural or substantive causes of action, and you also need to demonstrate that Ireland is the right place in which to bring this type of litigation. And so often you're trying to do that by establishing that the claimant has a deep-rooted connection to Ireland, and that the Irish courts are the best courts to assist in that. We were involved in one of actually the first injunction against persons unknown in Ireland, and we didn't know where the bad actors were located, quite likely outside Europe, based on what we did know. But we managed to bring in the court's jurisdiction by also issuing proceedings against the internet service provider, which was located in Ireland. And that was a way for us to bring in the ability of the court to issue proceedings against persons in wider jurisdictions. We also secured quite a novel order in that case, where we got permission from the court to serve the proceedings through the ransom portal that the hackers had set up to receive the ransom, which I think was the first of its kind also in Ireland. So again, looking at the Irish courts being able to sort of flex and take on a novel approach. Other types of applications that we see all the time are your Norwich Pharmacal orders, where you're looking for disclosure of details from internet service providers, etc., to try and assist clients in tracking down assets and utilising other remedies and reliefs. While that's an order that is an end in itself, it's often not the end for the client, because you need to try and figure out where do you go from there. And in terms of criminal prosecutions and convictions, there have been quite a few as well, and these are actually interesting and important cases because some of those cases have been taken by the Criminal Assets Bureau to seize crypto assets, and there has been an assumption and acceptance by the courts that the assets in question are the types of assets that can be seized by the Criminal Assets Bureau, and that in itself is an important piece that we can come back to in a little bit more detail later. But just a point that might be interesting in relation to one of the more recent cases. A small-time drug dealer had invested about 25,000 euros in crypto assets quite some time ago, and had, like many others, received quite a significant uplift in the value of his illegally and illicitly gotten gains. Criminal Assets Bureau brought an application to seize those assets. Courts were happy to grant that order, but not a happy ending, in fact, that despite the assets having now skyrocketed to the tens of millions in values, surprisingly enough, the criminal in question can't find the codes. Apparently, they were hidden in a fishing rod, which was taken from his house after he was arrested and may now be in a landfill in Germany. So with the best will in the world, the orders can be made, but the practicalities sometimes get in the way.
And that's what I'm telling someone understanding from that is that in the context of these injunctions, the context of these actions that need to be taken against these threat actors, there's a robust system in place, as you would expect from a country like Ireland. There's also something that's also to be noted is that because of the common law jurisdiction that we have, the precedents will be set by the Irish courts, but persuasive argument can come from those court cases that occur elsewhere in the world. And I'm thinking just when you were talking about service of through the portal, which I find hilarious in many respects, but there's also those cases which we observe in other countries, like the use or the decision by courts in relation to whether certain crypto assets could be used as security in a litigation, or whether crypto assets and digital assets themselves are to be treated as property. And I'm not going to refer to these specific cases themselves, but many of you online will understand what we're talking about. So it is from our benefit to look not just within the Irish borders of what decisions we make, but we'll be very mindful, and we will be keeping an eye on those critical pieces of developments in multiple jurisdictions around the globe. It's quite interesting for a country of our size that we take a very global view in keeping abreast of what could be taken in as argument or persuasive argument for the Irish courts. That's not to say the Irish courts will always follow it. I hope you would agree with that short assessment of that.
I think you're absolutely right, Rory, and it's certainly something that we keep a very keen eye to. I've mentioned at the outset watching the developments in the US, and Ian's touched on those in terms of sort of insider trading and the wire fraud cases that are taken there and how that might translate into Ireland. And certainly on the civil side, then one of the main issues that hasn't been determined by Irish courts substantively as yet is the issue of whether these assets, whether crypto or digital assets, constitute property in the traditional sense. Because if you have an asset that is a property asset, it gives rise to proprietary rights, which are very strong rights for those who have, you know, been victim of theft, misappropriation, fraud, whatever it may be. And whilst this hasn't been determined by the Irish courts, although accepted perhaps without much argument in some of the criminal cases I mentioned, it has been the subject of decisions in a number of other common law jurisdictions, which of course are persuasive and provide guidance for us in Ireland, and therefore we do keep an eye on them. For example, there's a couple of cases that have been reported from Singapore in which crypto assets have been accepted to constitute property because they fulfill, according to the court there, the hallmarks set out by the House of Lords in a case, the Ainsworth case, of what is a property asset. And whilst there was a bit of jurisprudence relatively recently that maybe the classes of property assets were closed, that has been debunked, and where an asset is identifiable, defined, can be assumed by a third party and has a degree of permanence, it fits the hallmarks of what is a property asset. And the courts in Singapore have found in a couple of cases that yes, we believe that these crypto assets do fall within that that categorization. Similarly, an interesting case in New Zealand, the case of Rusco and Cryptopia, which is actually a case around a liquidation, came to a similar decision, concluded that the assets which had been hacked and stolen did constitute property assets, and as such, those who had been deprived of the benefit of their property assets constituted creditors with proprietary rights, and therefore stood ahead of the general creditors of that insolvent crypto service provider, so that they would have a better right to recovery than those general creditors. And of course, that will be very important, again, in an Irish context, if you are dealing with insolvent situations. Similarly, in the UK, there have now been a number of cases, AA against persons unknown, and a couple of other, one in which actually an NFT has been recognised as constituting a property asset. And the English case law is always of persuasive authority or guidance to ourselves. As you say, Rory, we don't always follow it, but we do look to our closest neighbour to see what has happened there and whether we can draw guidance from it. And so there's no reason to think that if an appropriate case comes before the Irish courts, that a similar approach wouldn't be taken. And for us as practitioners and for our clients, it's really important, because if you have a property asset, you have a whole range of remedies available to you in terms of tracing, freezing, injunctions, all sorts of restitution type claims that really give you a much better armory to pursue bad actors if your assets have been misappropriated.
That's great. So we have hopefully given you a flavour of the Irish court system and also the legal system in relation to your enforcement actions and certain rights and remedies that could be available to you. It's interesting when we look at the regulations coming through to turn to that around the innovation, because there seems to be an element of innovative arguments being presented in the courts, but then we've got this level of innovation coming through from Europe. And I'd start even from my own basis. We've got the European laws that have been implemented in an Irish context around consumer protection, around copyright law, intellectual property rights, etc. So we've a myriad of those kinds of laws. Then there is local basis laws that deal with online safety, also around data safety, not just general personal data, but also children's data as well. And each of these things will, depending on the use case, depending on what the blockchain is intended to use and how it's going to use the data. Arguably, some people say it's pseudonymized is okay. No, pseudonymized is personal data. So we are fully aware of that, and guidance comes through thick and fast in relation to this. Similarly, in relation to clients looking for advice in relation to NFTs and the licensing of the intellectual property itself, but also just the contracts that need to be put in place for the marketplace, for the buying and selling of those particular NFTs. They're certainly coming through from us. So there's a lot of new things in theory, but because of the Irish system, we draw on a lot of the traditional laws that are in place that will help guide us, to help us navigate what appears to be new questions, when in reality they're just new takes sometimes on existing laws, and we just need to apply. Could they still stand firm? That's not necessarily the case for MICA. MICA's arguably is innovative. So it seems, maybe if I turn to yourself, Ian, is it really setting a global standard?
Yeah, I think it is, Rory. I suppose the aim here is for the first time, like an EU law which will apply across the whole of the EU, so 28 countries, setting out very clearly in law like what financial services are regulated by when it comes to the provision of digital assets, you know, and essentially the place the lawmakers have come from is that they want to firstly set out a clear legal framework for industry. At the same time, they want to encourage and support innovation in this area and in a way that will benefit European countries, including Ireland. And at the same time, they also want to address some risks which have grown up in the last few years, particularly in the areas of consumer protection and also to promote financial stability. So essentially what we have now, having been voted on by Parliament at EU level and just requires to be published in a legal gazette before it comes into force, is a bespoke regime for this sector. And I suppose what's interesting as a practitioner when I've read the advanced drafts is that where possible, the EU has tried to take existing concepts that have existed for many years in terms of other areas of financial services and adopt the same principles and just apply them to this new area of services and products. So in a way, what the lawmakers are trying to do is to level the playing field, so that, you know, if you're doing digital assets and there's a financial services component to it, you're treated in approximately the same way that, you know, a bank, an insurer, a payments firm would be subject to under law. And some of the areas where we see that are like, you know, things like market abuse rules for the first time when it comes to crypto assets. You know, up until now, it wasn't very clear if market abuse rules did apply to the trading and speculating of virtual assets on the basis that they weren't traditional financial instruments. The scope of the law also applies now in different ways to, you know, the issuers of tokens and other digital assets. You know, so if you're issuing a virtual asset or digital asset for the first time in Europe, you might need to publish a prospectus. Although, in keeping with the industry, the phrase white paper is used in the law. There's also, you know, new rules for things like stable coins, which are, you know, and other asset reference tokens. You know, so digital assets which kind of have a reference to like an underlying asset or a currency such as the dollar or the euro. And of course, you know, the regulatory perimeter has been clarified as well, in the sense that certain things now clearly remain outside of scope of financial services law in Europe, such as intergroup crypto asset activity, central bank digital currencies, non-fungible tokens are also outside of scope, and, you know, utility tokens and reward tokens might also be outside of scope. So if people listening today are in some of those areas and have found that their businesses have been bedeviled by a lack of clarity as to, you know, where does the line stop and start when it comes to regulation, you know, you will see in the MiCA framework at least a clear attempt now by lawmakers to you know, give clarity to the world at large on that point.
Thank you. But then what about liability? Are there issues there?
Yeah, well, there are, of course. I suppose that up until now, I suppose we've had a bit of a you know, a free for all, in the sense that liability was unclear. But, you know, if you're now being required to issue a white paper prospectus to the market, you know, you have to stand over the validity and accuracy of the statements made in that, and there's potential liability concerns there. There's also potential liability for, you know, platforms and exchanges that trade in these services, in these assets. And, you know, for example, if their information security arrangements or cybersecurity arrangements aren't up to scratch, then there's also potential civil liability concerns there. So, you know, these are natural responses to some of the scandals and weaknesses we've seen, not necessarily in Europe, but just, you know, around the world in different countries. And it just shows that, you know, if you want to be serious in this area, you know, there will be compliance requirements going forward, but nothing we wouldn't expect from pretty much any other kind of financial services provider either.
And I think particularly on the sort of civil side as well, I think what MiCA will bring as well is an ability for consumers to, I suppose, springboard off any findings from regulators, from the central bank. Yeah. There has been a deficiency. So, for example, as Ian mentioned, on the market abuse side, there's a real focus under MiCA on internal controls and procedures and having, you know, the appropriate measures in place. So obviously you can't get rid of risk altogether, but you can do your best to ensure that your systems are robust. And if there's a failing in that regard, there are provisions, existing provisions under central bank legislation, that consumers who have been impacted or caused harm by a failure to meet any particular financial services regulation can bring their own action for damages. Now, there is a question about, you know, the value, the extent of damage, the extent of loss, and how expensive it is to bring litigation for something like that. But we do have coming down the path very quickly representative actions legislation in Ireland. And so when you bring in MiCA and you bring in that legislative regime on class actions that's coming into play, you do see a whole other line of exposure, I suppose, for crypto asset service providers, which is akin to the type of exposure that any financial service provider operating in Ireland would have already. But generally speaking, again, it's, you know, it's a question of compliance, and it's not to say that there's a draconian environment in Ireland, but it is to say that the legal and regulatory framework does its best to create a stable and safe environment in which players and end users can operate.
Just to add on my own thought on that one was that, so I mentioned before DORA and NIS2 and GDPR and all those other provisions that are requiring to have those internal controls and protocols in place. Just to advise that if you're in scope for those, and there's a long list of entities that will be captured by those pieces of legislation, the guidance as to how to implement what qualifies as a robust internal controls is still undecided, and that's not just an Irish context, it's a European context. But we are hoping for that kind of guidance in the similar way that we got through the Data Protection Commission, through the European Data Protection Board, in having just collaborative conversations with other EU member states and with the UK, US and all that, because it is in all parties' interest to have an idea that this is what we're looking for in order to protect these assets. And I say this in a broader context because blockchain has multiple use cases outside of just the cryptocurrency piece, the crypto assets piece, or the NFTs. So a blockchain, it could include personal data itself, it could include child data, as you mentioned, consumers could be at any age, and there's different then pieces of the puzzle that needs to be thought through carefully, and in many ways a gap analysis to be carried out to see where's the overlap. What have we got today in situ? What will we need in the future? And how potentially could we close that gap in order to affect a robust compliance mechanism for what we'd all see is important for the C-suite? But if I could then quickly go into this, I'm going to slightly facetious. So the legal framework's now completely clear. Ian and Karen, you're all, it's crystal clear now.
Well, yeah, like it's getting clearer, I would say. You know, I mean, even within MICA, if you read it, like it's a very long piece of law, but even still, there's lots of fine details still to be clarified, and that's not surprising, I guess, given the technical nature of the area. For example, some of the EU regulatory authorities, such as the European Banking Authority or the European Securities and Markets Authority, are tasked with drawing up guidance on things like the authorization requirements for firms looking to get a license under this new framework to carry on business in Europe. There's also going to be some other guidelines on, you know, what exactly is considered a utility token versus, you know, an asset reference token versus an e-money token. You know, so like we've got the broad skeleton of a legal framework for this area being set out, which is really helpful. But the next few years are going to see a lot more clarity and fine detail come through. So, you know, I think we're getting there. We're certainly moving ahead in Europe faster than countries, other big regions such as the United States, I would say. But I think there's still a little bit more to go.
Yeah, I think from the perspective of kind of enforcement litigation as well, one of the cases that we're keeping a very keen eye on is the cheap trading case. I think Rory, you kind of adverted to it earlier in terms of, you know, can Bitcoin be used to pay a security for costs order in litigation? And the answer to that, according to the Tulip case, is no, not enough security in it. But what is actually going to trial, as many of the listeners will be aware, is whether or not developers have a duty of care to those who consume the product to I suppose really keep it safe, to update it, to prevent bad actors having access to it, and to create forks to recover assets that have been misappropriated. So there was a High Court decision in that that was overturned by a Court of Appeal decision, and now we're all waiting with bated breath to see what happens at the trial of the action. And that could be a really quite a large development in terms of the extent of the rights and duties of those developing blockchains and crypto assets. So I think there will be lots of people keeping an eye on that one. Again, Ian, you've touched on it as well in terms of, you know, insider trading, front running, that kind of thing, and whether or not it was really a Wild West or whether it was capable of sort of being brought to justice in various different jurisdictions. And what we've been looking at, particularly for those who have who offer services in these areas, and perhaps are looking at some of the cases which have grabbed headlines in the US. We've had insider trading findings. We have allegations of abuse of process being made against the SEC, but guilty pleas entered to criminal insider trading charges in the US. And how would that play out in Ireland, as I said? And we're looking at existing legislation, unlawful use of a computer, for example, to extract a gain, and whether that fits the crime and whether people can be brought to justice for that, or whether now under MICA you actually have the whole market abuse regime and how remedies that will present and deterrence that it would hopefully present as well. But I don't think it's clear as yet. I think there's still a bit of catching up between where the technology is and where the legal frameworks and regulatory frameworks are. And certainly you're always going to have that novel case which requires you to go right back to first principles to try and find an answer for the problem that's presented to you.
So we've been talking about current state of play, current regulations, enforcement actions that we're predicting either currently or what is definitely on the near horizon. But if we can look to what really we are now focused on most from a horizon perspective, from key issues to consider, maybe if I could turn, Karen, to you first on what's on your horizon that could be suggestive of what's on our clients as well.
I think what we're seeing a lot of, and it brings together a number of different sort of regulatory frameworks. So something that is really on the high priority list for clients at present in the financial services world in particular, and in tech world more broadly, is the whole issue of enhanced compliance requirements and the individual accountability obligations that go with that for officers, directors, for the C-suite that are looking at these fast-paced advances and how they impact on their operations. So certainly under the central bank legislation with the individual accountability framework that has recently been enacted, and how that's going to interplay with the types of obligations that are coming up and being, I suppose, enhanced and buttoned down under, for example, MICA and some of the other legislative regimes that you see. So for me, a lot of what I try and do is impart knowledge of other experiences to try and prevent others from having the same sort of misfortune. And really it is, what does the rear view mirror look like? If somebody, whether it's a regulator, whether it's a shareholder, whether it's a consumer, were to say a loss has occurred, it's occurred under your watch, what's your answer for that? It's really looking at what systems and controls do we have in place to make sure that we're meeting the compliance standards that are being imposed, that are best practice, so that if something does go wrong, at least it's not through through lack of oversight, that we've done the best that we can, and really doing that gap analysis, as I suppose, to see what else needs to be done.
Great. I think, Ian, before I come to you, the same question. From the purely tech space, what we're looking at is in relation to the data. So as everybody knows, data has evolved into its own area of law over the last number of years. But we're conscious of, I hesitate to call blockchain emerging technology because it's been around for a long time. But as yet, the use cases and the novel use cases themselves still needs to be tested from all angles. But we are anticipating across this year additional enforcement actions, or at least decisions from supervisory authorities like the DPC from various investigations, and whether the impact of those will have on such items like blockchain, cryptocurrencies, and the NFT space. In saying that, just to point out the obvious, is that generative AI may be something that I'm not sure yet, but I'm not the tech genius in this space. I would argue that if that was ever to be used as part of a service which is being used in conjunction with a blockchain asset, then we have to be mindful of, for example, what happened in Italy, which suspended all services of the use of ChatGPT because of the potential impact or processing activities of personal data. So it is, to the extent that is in Italy, but yes, it is quite likely that other supervisory authorities may take a similar position unless the necessary measures are put in place to remedy the potential vulnerabilities within each of these technologies or these new use cases or services. As I mentioned before, we've got blockchain as a service, as a concept, But I remind everybody, we've also got ransomware as a service, which is also sophisticated criminal activity, which is in play now for the last few years. The second area I would say is keep watching digital regulation. There's so much going on, there's so much overlap, and there are potential for additional regulators being brought from a national level, and how they interplay. Those decisions still need to be answered, and how they work effectively and seamlessly with each other about the issues that may cross over each party, each regulator. So it is still to be seen how that will be conducted in the most efficient and cost-effective manner for all parties involved. And the third area that we noticed, at least from across all streams, across the people here and across our digital economy group, is that clients are now seeking to be more proactive rather than reactive. As I mentioned at the beginning, the clock is ticking, and it might seem that maybe the AI Act might come in play at the end of this year with NIS2 and DORA across next year, the year after. That seems to some people a long way away, but for some clients, they are looking at how to cost this, what kind of resource they need to put in place. Are they going to be exposed in some shape or form? Could they involve themselves in the consultations around how these should be implemented, and put forward their voices and their thinking on how to effectively comply with this in a business-friendly manner? So from those three areas of enforcement, regulation, and proactivity, I think that's what I'm seeing on the horizon for clients coming across my desk. But Ian, across yours, and you were talking quite confidently across all the crypto space, what are you expecting to see on the horizon?
Yeah, I think the main thing is, in light of the past, 6 to 9 months, there's been a lot of adverse comments and publicity said around this industry as a whole, and in a lot of cases very well founded and merited, and I think the challenge for firms that we often act for in our practice is like, how do we set ourselves up as credible business propositions and distinguish ourselves from other actors in this industry who have perhaps not sought to behave in a credible or trustworthy manner. And oftentimes the answer to that is actually embracing the regulation that's coming down the tracks and building a business that's capable of scaling and adheres to best-in-class regulatory standards. So I think that's the challenge for a lot of the clients we act for. And there's, and I can see from one of the comments that's come in on the Q&A that I think regulators want to be able to regulate businesses that they can understand and can supervise properly. And if you're interested in building a business that's up for that, then I think you can go very far in this area and use these new frameworks to the best of your advantage and commercial success. But if you're just in it for a quick buck or to get rich fast at the expense of consumers or whatever, I think you'll find the ability to continue to do that in the coming years will be more difficult. So I think that's the challenge that the regulators and lawmakers are grappling with, and I think now it's over to business to respond to that and come up with products and services that people really want to use and get value from.
So if I could then just to look to some, we've got a bit of time, I'd like to just talk to one other additional question that came through. There's a few of them, but they feel to have the similar theme. I think one theme seems to be about, well, what if the regulator at home, say in Ireland, moves forward and then there is a potential conflict at an EU level? Are there concerns about that? Because as we all expect in business, we want certainty in order to deliver the business services. We want to be able to strategize and plan ahead without worry that there's going to be some conflict between the two regimes. Now, personally speaking, I don't see that being an issue because of the special relationships and the collaboration that occurs amongst financial regulators across the EU. But Ian, you're closer to this space. What thoughts would you have on this?
Yeah, like I would say, there's definitely a debate to be had, but you know, the debate, I think, has just been had on EU level, you know, and, you know, the countries and the regulators across European Union countries have now decided that, yes, we are going to have a legal framework. It's called MICA. This law has direct effect, and, you know, because of that, it means that it's not really possible for national countries to go off and do their own thing, make the bar higher, or conversely make the bar lower. So, you know, we have a harmonized standard now coming out across Europe, and I think that's to the benefit of business. I think undoubtedly there will be further dialogue and reform in the years ahead, and maybe the framework will be calibrated and adjusted to deal with new risks or new threats or new trends in this sector that haven't been contemplated right here, right now. I mean, the law is always somewhat playing catch-up mode against, you know, innovation and technology in every field, particularly in crypto or digital assets. But I think, you know, what you'll find is, you know, although even the governor of the central bank has made some pretty scathing remarks about digital assets, you'll also find that his organization will now be tasked with implementing and enforcing this new EU law in Ireland, and I've no doubt they'll do it to their best of their ability, but they'll also do it in a fair and balanced manner as well.
Thank you. So with the last few minutes remaining, we'll just maybe key takeaways of it. Conscious Karen's signal may have dropped. So Ian, what would be your top key takeaways from this session for everybody listening?
Well, I think it's the key takeaway is that, like, you know, this is a very interesting area, and, you know, perhaps after, you know, many years of there being lots of talk about the need for rules and clarity and regulation, what we're really starting to see now is like the conversation moving on it, turning a corner a bit, and, you know, we now have multiple frameworks coming down the tracks from lawmakers, and some of the points Karen has mentioned around, you know, the litigation side shows that, you know, the courts have successfully considered a lot of the points that arise from digital assets. So in a way, like, the novelty is kind of wearing off a little bit, and the law is starting to, you know, get its head around it, and, you know, that can only be a good thing, really, on balance, I think, for people who are, and firms who are really interested in making the best of this sector.
I agree. I think just to add on the regulatory point, although it may appear from how we're presenting that it is complex, admittedly, yes, it is complex, and it does require careful attention. But the purpose is to maintain trust in the market, trust in the financial systems, and trust in technology. So in my view, that is a good thing. I think another takeaway for people, just practically speaking, it is worth running just even preliminary checks, run your gap analysis as to how you will be complying with or implementing these pieces of legislation as they come into play, whether they apply to you or not. And having those decisions made early might give you some peace of mind, but also allow you to plan and strategize for the future, for their introduction, because contracts are being negotiated now, which have a lifespan that will perhaps go beyond the introduction of these pieces of legislation, which will require you then to revisit those negotiations. So having some foresight into, or proactivity, which is my third idea, being proactive in how you negotiate to be more streamlined and more honed on these points, might save you a lot more headaches in the future, shall I say, and having to reopen those contracts, reopen those positions or that business model, and shifting to a new change. The third thing would be, just as part of that strategy, factoring the cost, the time, the teams needed to make the compliances. Just keep an eye on new standards from this AI standards that are being developed. There's standards that are being considered from ISO. There's the Institute of Electrical and Electronic Engineers. Those standards may also help you, guide you in how, practically speaking, to implement and comply with these pieces of digital legislation. So as we are at the end of this call and this event, I'd sincerely like to thank you all for your attendance and your participation. Thank you very much for everybody who was able to send us a question before the event and also during. So thank you very much. And I also want to thank my friends and colleagues, Ian and Karen. I really do hope you enjoyed it. And for some today, we understand this is the beginning of your journey, and for others, the next step forward in unlocking trapped value in your business. But wherever you are, please keep this conversation going. And Matheson, and especially our digital economy group, will be here to support you in your next endeavor, be it in the creation of and please forgive me, I'll use the analogy, of the train tracks or the engine, carriages, or acting as the driver or passenger. We would be delighted to hear from you. Thank you.